Thanks everybody for coming in and logging into this session. Basically, today is going to be a very whistle-stop tour on the subject of intellectual property, and I've put the title as Prior Art versus Freedom to Operate because these are two terms that often come up when dealing with intellectual property when I find that I'm working with my academics. But I guess as we go throughout this presentation, this webinar today, it's going to go to a bit more deeper into the subject. And we're going to find out that prior art and freedom to operate may not necessarily be the most important factors to consider when thinking about intellectual property, but there might be some wider aspects to the subject that are more important. And so I'll be talking about those kinds of things, introducing to yourselves to these kinds of topics, and hopefully you'll get some benefit at the end of the presentation. So again, ultimately, I hope that at the end of this, you're going to walk away with some knowledge of how to best use the intellectual property that all of you guys are going to be generating. And I say here, it sounds a bit cryptic, but I'm going to say how to best use your intellectual property to achieve your ambitions, whatever they may be. And I guess as we go through the webinar today, a bit more clarity on what these ambitions might be achieved. So the other part of the title was mentioning academia versus industry. And it's something that comes up time and time again where people think about, okay, there are two different perspectives when working through intellectual property. There's maybe an academic perspective and there's an industrial perspective. I'm not expecting you to read all the words on the screen here, but I'm going to put myself at risk and generalize the world of academia and the world of industry, where I'm going to say in the academic spotlight, intellectual property, actions, funding, all these kinds of things are sort of put in the context of generation of new knowledge and the dissemination of this new knowledge. That's the main focus. It's a primary focus that drives academia. But then fundamentally on the industrial side, on the industry side, new knowledge is generated, intellectual property is generated. But really, the focus of such activities isn't just to share the knowledge broadly, but very much it is about the idea of achieving some return on investment. And so fundamentally, I want to make sure that this setting is put forward as the pretext to the entire webinar, where we have in the world of intellectual property a combination of two very, very different perspectives. One about sharing and one about essentially making money. And so I'm going to go through now what this means. Just interestingly enough, the area that I work in, technology transfer, is all about trying to bridge these two perspectives. And so a very short one slide on where I work. I work for Cambridge Enterprise, the Technology Transfer Commercialisation Office of the University of Cambridge. I will say that pretty much every university in the world has a similar office. Sometimes it might have one person in there, sometimes it might have 50 people in there, but every university will have such an office, and the office exists to effectively do what I said before, trying to marry the worlds of academia, where knowledge is generated and shared, to one of industry, where the knowledge is purposed towards essentially creating a return on investment. So today, three areas that I want to cover. One, the basics. Two, going a bit deeper about this academic versus industrial strategies. And three, finally summarizing with some key learnings which I hope you can take away and which I hope will benefit your work moving forwards. So the very beginning. Now, I'm not exactly sure where everyone is coming from in terms of their background to intellectual property, but I thought we should try and set a baseline and make sure we're all on the same page. So I'm going to start off very beginning. Intellectual property, what is it? Any form of original art, original something that can be bought or sold. And the key word there is property, right? We all know what property might be in terms of, say, real estate or in terms of ownership of an object. Intellectual property, same sort of thing, except we're talking about knowledge. And it's about how, in many ways, you can define knowledge in such a way that it can be potentially traded, sold, exchanged, licensed, just like something of, just like a physical object, essentially. But when it comes to intellectual property, so the IP type of property, we then start introducing aspects of law into it. And so then as we consider what we can do with intellectual property, then we've got to think about the legal rights that exist and the legal rights that may exist in different countries, in different areas, so on and so forth. Ultimately, if we can define intellectual property as something that can be traded or used or exchanged, it then allows other people, or rather, it then allows the generator of the intellectual property to benefit from what they have created by essentially packaging it up and give it to someone else to do something with it. And I think in terms of the university versus industry context, it's very it can be quite clear here. A lot of research that goes on in the university goes into products and services that we see every day. And these products and services are probably never going to be manufactured or sold by the university itself. Someone else has got to do it. Someone else will be making money from it. And so, again, coming back to the point, intellectual property is a way of defining this knowledge in such a way that it can be transferred onto someone else who can then exploit it. And in some way, in some exchange, some monetary return is spread across all the different parties involved. So, intellectual property rights. What are some examples of intellectual property? I think Coca-Cola and the bottle and the brand itself is a example that's very commonly used to describe the full spectrum of intellectual property rights that typically exist in the world. For example, you have how something works or what something technically is, a technical definition of a product. And this type of intellectual property is defined in patents. When we look at the Coke bottle and look at the way the logo has been developed, it's probably hard to see, but you've got underneath the Coca-Cola label, it says a registered trademark. And so trademarks are another form of intellectual property. And the idea of trademarks is it is a marking that tells people the origin of a product or a service. And in hope that when people see that trademark, they relate it to a certain level of quality or reputation behind that, that product or service. Moving forward, we have expression of ideas, copyright. So we think about things like software code, written works, pictures, photographs. These types of things are covered under copyright. When we look at the design of something, again, the shape of the bottle in this instance can be defined and registered as a design right. So another type of intellectual property right. We've got the recipe of the drink. Everyone typically says that it's a mysterious recipe locked in a vault somewhere in some bank in New York. Again, this is about know-how, or basically the knowledge of how to do something that isn't necessarily disclosed publicly to anyone else, another form of intellectual property right. And I guess becoming more common now is a subset of copyright, which can be called database rights. So collections of data. Yeah, and the design of databases as well. These kinds of things can be covered in various ways and defined as intellectual property, which I said before can be packaged up and somehow exchanged. Now, looking at these types of rights, one type of segmentation that you can divide between the two of them are registrable rights and non-registrable rights. So the ones that are that have been drawn around on the screen, patents, trademarks, design rights, these are all things that the rights don't automatically exist, but you need to apply in a particular jurisdiction to attain those rights. Whereas the other ones, they pretty much exist at the time of creation, that you don't need to formally register those rights in order to enforce the laws that you have behind those rights. So again, the point is, as a type of property, these things can be owned, sold, acquired, licensed, destroyed, etc., according to the laws of the jurisdiction in which you're in. So typically, the types of country, it will be different between various countries. Finally, it's about what do these rights typically give you? Well, in many ways, holding a patent or holding a trademark or copyright or design right, it doesn't give you the permission to exploit those rights that you have. So it's not an enabling factor that enables the holder or the owner to make money from the intellectual property, but rather it's what is called a negative right. So, for example, if you hold the Coca-Cola trademark here, it's not necessarily your right to go out and sell products underneath this trademark, but rather it's the negative right that enables you to stop other people from selling products underneath that trademark. Likewise for patents, if you hold a patent on an invention, it doesn't give you the right to practice that invention, but rather it gives you the negative right to stop other people from practicing that invention. And so that's just a point to bear in mind if you haven't come across it before. When we talk about intellectual property rights, typically it's always about the right to stop others from doing something that you have effectively. So bearing this in mind and moving forward now, as you can see, there's a lot of different types of intellectual property rights, far too many to cover today in this 1 hour session. So I'm going to be focusing more on patents specifically, because these are the most common types of intellectual property rights that are generated, and particularly within university environments and in research programs, these are the ones which more often than not generated, registered, and attempted to be commercialized. So with that in mind, I'm going to be focusing on patents, and I'm going to be initially in this first section going through some of the overarching principles or considerations that need to be known in order to say, get to think about how you can potentially secure and register patent rights. And these things are considerations around inventorship, i.e. who came up with the inventive steps of an invention, ownership, who owns, the idea of confidentiality and disclosure, and under this umbrella we introduce the area of prior art. And the last two, which I'll be focusing less on, but again, it's bringing up the point of what these rights give you. It gives you negative rights, and that's where the point of freedom to operate comes into the picture. And lastly, of course, what you can do with intellectual property, and I've got their licensing, But that's one type of thing, activity you can do with intellectual property. But I'm going to be talking about mainly inventorship, ownership, confidentiality and disclosure, and underneath that, the idea of prior art and why freedom to operate may or may not be so important at the early stage when considering patenting. Again, I just like to make sure that when thinking about patenting, these principles here relate to you could say, the process of patenting, i.e., if I want to patent something, these are the considerations I need to cover. These are the principles I need to be familiar with. At this stage, in this first section, I'm not talking about why somebody should think about patenting. That comes in section 2, but rather these principles here are all about the process of patenting. If you wanted to patent, these are the things that you should be aware about. So the first one, inventorship. Who invented? Who's an inventor on a patent? Who's an inventor of intellectual property? And I'll just let you read those words on the screen very, very briefly. The takeaway from this is that it's not particularly easy, or it's not a single sentence that can define who an inventor is on a patent. There's a lot of considerations that you need to make, and it really depends. But these are some of the considerations again. When it comes to thinking about who's an inventor on a patent, we always get the type of cases where a PhD student or postdoc may have done pretty much all of the work behind an invention, but maybe some of the initial ideas or steps along the way were influenced by the supervisor. So, the question mark there, does the supervisor or PI, are they an inventor on a patent that they may have contributed, 1% of the, say, physical work behind it? That's a question to be asked. Different collaborators that take part, consultants, these are all things that you should really try and think about when it comes to, say, patenting or in the creation of any intellectual property, really. Who contributed to what? That's basically it. I can take questions on this later if you wish. But the second point is, and this is more to the point, is about who owns. So you may have a group of people that come together to create an invention that is patented, but then you got to consider the rights that that the people who fund such inventors may have, of any intellectual property that's generated. i.e., if you're typically an employer of a company and you generate intellectual property, then often or not, you would have signed your employment contract, which says that the IP you generated is owned by the company. Every organization is different, therefore I've only got my university's key points there. But it is a distinction when it comes down to, say, if you're a PhD student or a different type of student at a university, you're technically not an employee of the university, and therefore you might not be covered underneath the default intellectual property rules that employees would sign up to. But if you're a PhD student or any other kind of student and you are on a scholarship or studentship, or you might be supported by an industrial partner to carry out your work, all these third parties, as we call them, may have rights to intellectual property that is generated. And that's what I guess the key point about it is, okay, you have inventors on intellectual property. Those inventors can only really do what the owners of the intellectual property or allow them to do. So being an inventor on something doesn't give you the automatic right to exploit what you've invented. It comes back to, well, who paid for it, who supported it, who might have what they call third-party rights to your invention. So just another consideration to take into mind when thinking about the creation of intellectual property, particularly patents. The third point that I had there was about confidentiality and disclosure. And now this really starts going into the mechanisms of wanting to patent something. Because one of the key considerations when patenting is to really think about, well, two questions. Is what you have created, is it novel? Is it new? Has it never been seen before in public anywhere? And the second one about being inventive. And this is where it comes down to saying, okay, what I've come up with isn't obvious, and I say obvious in inverted commas, obvious from what else has been described already as the prior art. So basically, if you're carrying out research and you say publish your work at a conference or in an academic paper in some journal, then generally the novelty aspect of your work has been taken away because the ideas, your findings have been released into the public domain, therefore it's not novel anymore. Inventiveness is something a bit more complicated. I will go into that in a second. But again, focusing on the first aspect, novelty, people always ask me what constitutes publication, and quite literally, it is anything that's not confidential, essentially. It can be a poster on the wall in your building. Again, publications. It can be a PhD thesis, and it says that unless restricted from public access. So a lot of universities, when you submit a PhD, they would scan a copy and put it online on the library website in some database, which is searchable via public. That constitutes a public disclosure. If you were talking about it in a cafe openly and somebody were to have some record of it, they could prove that you were talking about it in a public area, and then that can count toward taking away the novelty of your invention. So it can be literally anything that isn't confidential. Again, I'll just put a disclaimer in here. If you got any particular questions, you need to treat this on a case-by-case basis. So talk to someone like your tech transfer office, about what you may have said, not said, what you want to say, in order to get an opinion on whether or not it would affect the novelty of an invention. And just to highlight the point here about being novel, and I say, anything in the public domain can count against the novelty of an invention. I've got here a diagram, a figure from a patent application from 1983. Now, the invention is an entry signal system for pets. So this patent application was submitted to, I believe, the US Patent Office. And what happens when the patent is submitted is that an examiner from the patent office will go through and try and find anything in the public domain that will take away from the novelty aspect of it. And in this case, this was the example that was found that basically removed the novelty of the invention. They basically found a comic from 1981. So 1981, predating the patent application of 1983. And again, it's a comic book, which shows a pet ringing a doorbell. Therefore, the idea is not new. Therefore, in this case, the patent application was deemed to not be able to be achieved. So I think this example highlights quite nicely that anything in the public domain can count against the novelty of an invention. But when we go into inventiveness, this is where it gets very, very subjective. in that, and it's worth here talking about briefly the process of patenting. So you've identified the inventors, you have understood who owns what, and we figured out that you have permission to file a patent because your organization may have rights to it, may own it. You've gone through and you've found that your invention is novel, i.e. you haven't found anything about it in the public domain, and therefore you draft a patent application and you submit it to a patent office. Go over some time and somebody called an examiner from the patent office will review your application and will try and dig up anything to count against the novelty and the inventiveness of it. The example before is an example of an examiner finding something that counts against novelty. But then when it comes to inventiveness, I'm going to come back to this again. It's very subjective. You can try your best to show that you're inventive, but at the end of the day, you're only going to find out whether or not you have something inventive after the patent goes through this examination phase. And essentially, you're relying on a subjective opinion of an examiner reviewing your work against whatever he or she has found in the public domain. So, for example, it's subjective because an examiner in the European Patent Office may find something that an examiner in the US Patent Office might not have found. So they would have different opinions, therefore, what is inventive. Within the same patent office, you could have two different examiners going over a patent, and they may find different things as well. And again, so it's going to be subjective depending on the actual examiner. And the examiner may have had a very, very bad day, or may have had a very, very, very good day and decides to spend a long, long, long time digging up everything he or she can find in the world. And again, come up with a different opinion on whether what you have submitted is inventive or not. It's really, really subjective. You're not going to know until it actually goes through examination. But all you can do is try your best. To put forward the argument that what you have submitted is inventive. So I'm going to go through very quickly an example of what I've just described. So on the screen now is a copy of a international search report from a patent which I randomly searched. And typically in this report that comes back from the examiner after they've done their search, you would find some of these tables. And the middle part where you can see XAAA, these are documents or pieces of prior art that the examiner has found, and the X and the A relate to essentially the type of problem that these documents may pose to the novelty and or inventiveness of the application. And so in this case, we've got one X, and I just want to highlight here what does the X mean. In this case, it means that the claimed invention cannot be considered novel or cannot be considered to involve an inventive step when the document is taken alone. Now, in this case, we haven't got any Ys, but Y is worth bringing up because it says the claimed invention cannot be considered to be involved in an inventive step when the document is combined with one or more such documents, such combination being obvious to a person skilled in the art. So these start bringing up some technical terms with patenting here. The idea of I said before, novelty and inventiveness from a single document or from a combination of documents from a person skilled in the art. Again, what is a person skilled in the art? There is a legal definition for what this person is. Essentially, it's someone who has no inventive capability, but somebody who can read publication 1, textbook B, web article number 3, and by simply combining these three things together could come up with your invention. Again, it's a very subjective thing. But essentially, when it comes to inventiveness, oftentimes we have people saying, oh, I haven't found any one piece of work out there that describes what I have done. But you got to go a bit further than that. If you were to take ideas from 10 different sources and combine them together, does that effectively communicate what your invention is? If so, there may be some grounds for an examiner to think that your invention isn't inventive. Again, it's subjective. And so this relates to, well, as you can see, it's not only subjective, but it's very, how can I say, it's very in the detail. And so a question we always get asked when it comes down to filing patents is, can I file a patent myself, or do I need to go with a patent attorney? My advice at Cambridge Enterprise is always, well, if you want to patent something, yes, it costs more to use a professional patent attorney to draft it and to submit the application, but the money that you spend for them to go through all these little fiddly things with inventiveness and going to court and defending your position on inventiveness, it's worth every cent in the world, to be honest, because it's a very, very, you need to have very specialist knowledge to be able to hold your arguments well in this area. But again, this comes to the prior art, the idea of prior art. Why is that an important consideration? Because if any prior art comes up, it may affect the novelty and inventiveness, and that may affect the overall ability for you to secure a patent in the area. The other term, which is freedom to operate, often comes up, and I find that some people often confuse freedom to operate with prior art. They may be a bit similar, but they are actually quite different. So as I said before, prior art is all about what exists out there that may impact the novelty and inventiveness of being able to claim an invention. But when we look into freedom to operate, it is very much that. If you hold a patent, as I said before, a patent gives you the negative right to stop others from practicing what you have. So freedom to operate in this context is there anyone out there that holds patents that will stop me from carrying out my patent, stop me from trying to commercialize my invention that I have defined in my patent? And we have various scenarios when it comes to freedom to operate. Scenario one is on the screen. In this case, to answer the question, you found that, okay, a competitor company may hold a patent, and when looking at our patent side by side with theirs, it's very clear. There's no overlap. It's very distinct. They don't have any negative rights against us, and therefore, in this case, both parties can go on and exploit their patents without any problems. That's probably the ideal scenario. Going further into freedom to operate, scenario two could be, okay, you have a competitor company out there, they hold a patent, and we have invented something new, and it takes the competitor's product and it goes beyond it. So, it fully encompasses the competitor's product and extends it further. There's something new and inventive that we've added on top of what our competitor company has. In this case, it's a bit more tricky, because even though the prior art situation is fine, i.e. we have something new and inventive, and we've been able to prove that in a court, in terms of the actual invention itself, we are using all of our competitors' invention plus some more. And in this case, we would not automatically have the freedom to operate to practice our new invention unless we have secured the rights to practice our competitors' invention as well. So this is an example where freedom to operate and prior art are sort of two different considerations to have. In this case, scenario 2, the prior art situation is good, but the freedom to operate isn't so good. Scenario 3 could be, okay, we have a competitor and they've got their patent and we've done our work and we have used some of the ideas of our competitor's product, but not all. And then we have done something new and inventive beyond that. In this case, because we haven't used all of a competitor's invention, and we have something new and inventive over the small part that we have used, in this case, we not only have a good prior art situation, but we also have the freedom to operate, to practice what we have without requiring access to our competitors' patent as well. So these are the 3 scenarios typically that you get with freedom to operate. Again, I'll just say again, the aspect of inventiveness, that's always going to be subjective. But the key point here is that when it comes to freedom to operate, the types of documents that you got to evaluate are largely focused on patents. So whereas prior art searching involves anything that has been disclosed in public, when we undertake a freedom to operate exercise, it's really comparing the claims of a patent to whatever claims that we're trying to make in a patent. So again, you're looking at 2 different sets of data here when carrying out the different activities. Also, when carrying out freedom to operate, it's about searching patents which haven't expired, basically. So they need to be within the 20-year period of which a patent can be enforced. All right, so I know I've rushed through those basic ideas behind intellectual property and patenting quite quickly, but hopefully it gives us a baseline now to consider, the academic versus industry perspectives and strategies behind intellectual property. And as before, where I was talking more from the perspective of if I wanted to secure intellectual property rights, if I wanted to patent something, what other considerations I need to make. Now I'm going to be talking about why would you want to secure intellectual property rights and why would I consider patenting as a means to secure intellectual property rights. So different twist. And I think this diagram here sums up the key message of this section, which is when it comes to why you should patent something, why you should generate intellectual property and register it or try and formally declare it, it really comes down to the commercial objectives that you're trying to achieve. So when we're talking about a patent relating to an invention, what is the market that this invention is going to go towards? What is the business strategy that will help take this invention to market? Sitting behind this business strategy and plan, what are the operations within a company, the types of products and services that you want to develop, the R&D you want to do, that kind of thing. And intellectual property strategy is really an enabler, a means to enable the operations of a business. And it's a means to enable the successful execution of a business plan for commercial objectives. So, why should you consider patenting something? Why should you consider enforcing intellectual property rights? The answer is because there's some sort of commercial objectives that we want to pursue. So sometimes we have people who come to us wanting to patent something because they see it as another means to get to put on their CV alongside their list of publications. Honestly, I don't think that is a valid reason for patenting. Patenting is, or in fact, declaring intellectual property is about trying to support commercial objectives. And again, when we come down to commercial objectives, academia versus industry, two different commercial objectives. In the academic spotlight, the commercial objectives for wanting to file patents is about, these are some reasons why academia is uses IP to go beyond the knowledge dissemination. It can be used to attract commercial partners to work with the university, to get more research funding, to show real-world impact from the taxpayers' money that the organisation, receives money from. These are commercial objectives of a university, of an academic environment, that often drives the push, if you will, to secure intellectual property. But again, we have a slight mismatch where on the in this industry side, it's very much on return on investment. The idea why you want to generate new knowledge is because you want to create new products, new services that give the company a competitive advantage against its competitors. So it's a much more focused goal in industry versus academia. The idea also is that on the industry side, such goals have different timeframes to it. So if they were talking about increasing next year's or next quarter's target, then they would want intellectual property that can be commercialized within a few months. But whereas if they're trying to work with more future product lines that may come online in 1, 2, 3 years, then again, sort of cycle times are different. And all these things can influence the way the attractiveness of intellectual property and what it means to the commercial objectives. When it comes to timing, this is one example of how it can influence it. So what I've got on screen now is a very typical process of how patents are developed from a university. So the motivation here for universities are to delay any big costs associated with patents, and to buy as much time as possible to further develop the research before having to lock down the specification of a patent. And so we often try and draw out the activities by filing an application in country and then doing something called an international application before diving and spending a lot of money to secure patent protection in different countries. Takeaway here is that the motivation for many universities is to delay costs. And in this case, this is the method where you can delay the big cost of national filings by up to 30 months. But as I said before, for a company, they may want to have the ability to exploit and to have a granted patent as soon as possible. So they may be more willing to spend big upfront, but in fewer countries in order to drive forward that timeline. So this is just one example of how there's potentially a mismatch between academia and a mismatch between industry approaches to intellectual property and patenting. Also, when it comes to the scope of a patent, oftentimes you might hear people talking about, they have a very broad patent on a particular invention, or they have a very narrow patent or a very narrow set of claims. And this really relates to the position of academia versus industry. When patenting work from a university, from a research outcome, the application may still be very wide, and there might be a lot of uncertainty around where it may actually be used. And so when universities file a patent, they try and cover as many potential future opportunities as possible. And their claims would show a very wide invention. Whereas with industry, again, they already may have an existing portfolio of patents covering a whole heap of different areas, and they may be interested in securing one little tiny aspect of it and getting that done very quickly. So again, another difference in perspective when it comes to university versus industry type patenting. I'll say this is typical, not always the case, but generally it is often the case. So when it comes down to then that idea of, coming back to the topic, prior art, freedom to operate, you can see potentially how there's academia and industry have different weightings behind the importance of prior art and freedom to operate. For universities and academic environments in general, prior art searching is a huge priority because you want to get the broadest patent. You want to understand what else is out there so that you can cover as much as you can. Whereas on the industry side, because they're focusing on a very narrow invention to begin with, potentially they don't need to search as far and wide to determine whether they're novel or inventive. And when it comes down to freedom to operate, again, for academia, it's unlikely that they're going to be exploiting the patent anyway. They want to potentially license or create a company that will exploit it on their behalf. So the freedom to operate problem isn't necessarily with the university or with the academic environment, and so it really isn't a priority. But if you're seriously thinking about commercializing, you need to make the intellectual property attractive to somebody who would exploit it. So doing a little bit of thinking around freedom to operate at the very early stages, which can influence the work that you do to potentially design around existing patents. These are things you can do at an early stage to make academic patents more attractive to industry. When something has already been patented and industry have licensed it and they need to get the freedom to operate to do it, because they have potentially a lot more money, they have a big business case behind why they want to invest money in this intellectual property to generate new products or services. They may take steps to secure the freedom to operate by licensing in or by buying in the technologies that they don't otherwise have access to already. So again, a different perspective on how to overcome the freedom to operate problem from an industry point of view. But the final point is, I just want to bring it back, that this middle section, the idea of why you would want to generate intellectual property, why you would want to register intellectual property, register patents, it really must come down to, how does what you have support the commercial goals that you're trying to achieve? All right. So the final section now, key learnings and potentially things that you can take away to help you in your work if you're thinking about commercialization. I just want to bring up that diagram again and just reiterate this point. As you can tell, I can't make this point, I can't stress this point any more than I have already. When it comes to patents, when it comes to intellectual property, it is about what is the commercial goal that you're trying to achieve. That is the main point that you got to. If you take away any point from this entire webinar, it's this point here. So then you think about, okay, I do have a commercial goal. Then it's about thinking what type of intellectual property would best enable this goal to be achieved. And so before, as I said before, there are different types of intellectual property rights: patents, trademarks, know-how, copyright, etc. And in terms of the options for working to commercialize, each of these different types of intellectual property rights have a different role to play in each of these different options. So when collaborating with industry or consultancy work, sometimes a lot of this can just rely on know-how, the know-how you have, and you don't need to formally declare or register a patent to enable this. When it comes to licensing or forming a new company, that's when you start thinking about more formal registered intellectual property to enable these kinds of options to be successful. Now, hopefully, again, this talk is about prior art freedom to operate. There's two takeaways on this point, noting that the point I'm trying to make the most from the webinar is about intellectual property to enable commercial outcome. But in talking about prior art and freedom to operate, all I'd say to you guys is, if you want to look at prior art, search everything, search everywhere. If you're thinking about trying to register a patent, there are going to be things out there. As for freedom to operate, realistically at this stage, you probably don't need to think too hard about it. But really focus on number one. Know the field that you're in, know your competitors, know what's going on out there. And so finally, if there's any sort of process or cycle when it comes to intellectual property generation and supporting a commercial goal, this is sort of a high level summary of it. Number one, it's about the auditing of the information. So the idea of, if I want to patent, do I have the ability to do so? Do I have the ownership rights? Do I have all the rights to do so? That's the auditing part. If the answer to that is yes, then you can go through the assessing the commercial opportunity, creating the IP strategy and business plan to best support the opportunity, and then carrying out the necessary actions to address freedom to operate, to address prior art, so on and so forth, and hopefully get it to market and make something of your intellectual property that you generate. In all of this, I'll finish up by saying there's a lot of things that have been covered today. Definitely not in the depth that would probably give you confidence to go out and do it by yourself, but that's not the point. The field of intellectual property, prior art, freedom to operate is a big field, and there are a lot of people out there that have services to help people navigate it. So if you're venturing down the route of exploiting your intellectual property, seek help, seek advice, talk to your technology transfer office, talk to a patent attorney. Don't try and go at it alone. And that's the end of the presentation.
Ben, thank you very much for this interesting presentation, and also for guiding us through this very complex area of law. I have not received any questions as yet, but I have two questions, if I may. One is about geographical limitation of patents. Is there any, when I file a patent, is there any geographical limitation of it? So if I file it in my own country, or if I file it in Europe, does that mean anything in terms of geography?
Sure. So yes, in order to have that negative right to prevent others from doing something with some intellectual property that you have, it does come down to the territory that you file in. So, for example, if you were to file a patent in Portugal, you would have the right to stop others from making, selling, distributing that kind of product that you have in that territory.
In Portugal?
In Portugal. It doesn't give you the right it doesn't enable you to stop someone in the USA from doing it. But consider this: if a company in the USA wanted to sell a product that you have a patent on in Portugal, you could stop them from doing that. So, therefore, when people patent in different countries, often they look towards the countries where either there's a big market where they want to sell into or stop others from selling into, or it's a territory where there's a very, where it's going to be manufactured, and so you can stop other people from manufacturing that kind of product there. So, sometimes you might want to protect in China, but you never want to sell in China. You want to sell in Portugal or Europe or elsewhere, but you know that the likelihood of manufacturing in China is very high, and therefore you could stop anyone from making your product by going in that territory.
So when this is the case, it's better to file a patent in different countries, looking at the market and the manufacturing of that kind of product.
Yeah, exactly. And that's where it comes back to the point of, well, yeah, where do you file? What countries do you file in? What territories do you file in? And when it comes to things like manufacturing strategy, distribution strategy, where you're going to be marketing, it all comes down to the business plan, the business decisions, the commercial decisions. And so unless you've developed that alongside your intellectual property strategy, you're never going to have the full picture to know what the best way to proceed is.
Another question I had is more related to your role in commercializing intellectual property. So, are you going after intellectual property within your organization or at the university, or it's the researchers that go to you with requests? How does it work?
It's both. So you could say that most of our intellectual property is researchers who come to us and with their idea, with their invention. But we do spend nearly half of our time going out there, making people aware of intellectual property and what it means and the ideas of commercialization, in order to attract people to come to us effectively. That's the general idea behind it. And the motivation behind that is it comes down to that idea of prior art, because sometimes, the researchers have this great idea and they may come to us and we think it's a great idea, but then they tell us that, oh no, they already published the idea in a publication, a year and a half ago or 3 months ago. And then when that happens, because of the ideas behind prior art, it really limits us to what we can do. So therefore, we always try and get out there, make people informed, such that they're in the best position, if they wanted to commercially exploit their intellectual property, to do so.
All right. Thank you very much.